The Honourable Member for Toronto-Danforth.
Thank you, Mr. Speaker. If you can let me know when I have 5 minutes, I have 20 overall, I'd appreciate that. My remarks today will be on a series of sections in Bill S-7, sections 4 through 8, which add a number of sections dealing with the question of leaving or attempting to leave the country for purposes related to terrorism. Now, these proposed new provisions on making it a crime to leave or attempt to leave Canada to join up with a terrorist group or participate in a terrorist activity, they do respond to very real concerns. Now, assuming especially the accuracy of testimony before the Senate, there are worries about a non-trivial number, even if proportionately a small number, of citizens or permanent residents contemplating leaving Canada for this reason or already having done so. There's reason to believe that male youth, whether under age 18 or young men who are over age 18, in some diasporic communities are targeted especially for recruitment to join in terrorist activities abroad. So there is very much a reason to be concerned. All that noted, we are led, as we must always be, when youth are highly likely to be the main subject of criminal law measures, to wonder if criminalization will be as productive a measure as its proponents hope. Now, let us assume that we all believe in preventative measures of a social, educational, mentoring sort, alongside addressing root causes of alienation that lead to the kind of radicalization that we're concerned about in this context. The question then becomes, what will be the value of criminal charges against youth arrested at airports or other borders seeking to leave Canada? At least for those under age 18, it is true that the Youth Criminal Justice Act will apply, and that act does allow for holistic education-centered sentences, for example. Now, that's a good thing, although one does need to remind everyone of two caveats. One is that youth still receive a criminal record, and secondly, that the Crown can always seek to apply for adult sentences. However, once one reaches that magic number of age 18, we are left with the full-blown application of the criminal law. At minimum, we need to know that the approach of government is more multifaceted than reliance on these new criminal code provisions alone. Now, in this respect, one thing these new provisions proponents have in common with those of us who are concerned to promote non-criminal measures to divert people, especially youth, from radicalization of the sort that embraces violence, and that is prevention. Now, if this prevention could be achieved in ways short of the cumbersome and often clumsy invocation of the criminal law, I suspect that some productive consensus could be arrived at. The problem, however, is that it's very hard to design coercive measures to prevent a person's departure shy of using the criminal law, while still remaining faithful to principles related to liberty and the rule of law that we cherish. Now, it might be thought that one way to use the criminal law in a way that falls short of full-scale criminalization would be for these new provisions to be used as the basis for detention by the CBSA, the Canadian Border Security Services Agency, and then arrest and charge by the RCMP, but then have the Crown decide not to prosecute. Now, keep in mind here that when I say the Crown, I mean the Attorney General, because these new provisions are amongst those in the criminal code that requires the Attorney General's consent to prosecute. Now, when one reads the Senate committee records for Bill S-7, one does get the impression that there may be, in part, some who may mean by the new provisions this kind of idea in terms of the preventative purpose. Now, if these new provisions allowed the state to prevent people, for example youth, from joining terrorist enterprises while not resulting in criminal convictions and sentences, would this not be a defensible result? One has to ask the question. But the answer does seem clear. criminal law will not be able to function within acceptable limits if it becomes a tool for disruption, whereby arrest is the end goal but not prosecution. The more a system can be used with no real intention of prosecuting, the more it will, over time, be used in exactly that way. For the criminal code to maintain its integrity, its invocation must only ever be on the basis of good faith at each stage of decision-making that's relevant, good faith that there's an adequate evidence to sustain a prosecution. All of which leads to the question of whether we actually do have a prosecution system here in Canada that's willing and able to prosecute, considering that much of the evidence for the new offences will be produced from intelligence that CSIS and perhaps other agencies may well not be prepared to allow to go to court for fear of revealing sources and methods. We know from, for example, the Air India inquiry, how such considerations can inhibit effective prosecution. And we have no reason to believe that the prosecution capacity has changed since the 2010 Air India report. And so we may end up with a system that theoretically allows for proof of intention to leave the country for these purposes. We can all imagine a range of kinds of proof, ranging from emails, parents or community members, provision of information, information from foreign intelligence, and so on. So a system that theoretically allows for proof of intention is possible, but in practice it may lead to charges being dropped because intelligence agencies won't want evidence made public. If so, we may be inadvertently ending up with the criminal law being used in the way I just talked about earlier, as a means to disrupt behavior with limited prospect for use for its prescribed purpose of criminal prosecution. So in committee, this may be an issue worth probing. Will the sort of evidence available actually be usable before the courts? Let's now look, Mr. Speaker, at another challenge, at the interface of acquiring evidence of intent to leave the country for this purpose and logistics. And this is the issue of how all of this will work at the point of exit from Canada. At the moment, we all know there are no exit controls at all at the border, especially notably at airports, other than no-fly lists for those deemed to be a threat to aviation. Testimony before the Senate made clear that cooperation protocols or memoranda of understanding will be needed between CSIS, the RCMP, and the CBSA. And Mr. Fadden, the director of CSIS, went further and noted that it would have to extend likely to CATSA, C-A-T-S-A, the agency of the Department of Transport that regulates security. Now, how these protocols will be developed and what kind of accountability for their operation will be remains a concern, especially because the RCMP, a key link in the interagency collaboration that will be needed here, has been shown by both the Arar and the Air India inquiries to be an agency that suffers from lack of accountability and appropriate oversight mechanisms. And yet, with the government's Bill C-42, we see that this government has no intention of acting on the Arar Commission's carefully thought-through recommendations for RCMP accountability and oversight. But there are two comments by Director Fadden that most definitely will need to be followed up in the committee here in the House after second reading. Let me turn to the first one. Here's what he said, and I quote, "I emphasize that we have not developed the protocols yet. What we will need to do is work closely with the Mounties and make sure that we are communicating at all times with border services. The other complicating factor is that Canada has no system for controlling exits. We do not even have a system to be aware when people are leaving. This will involve more than the CBSA. It may well involve CATSA, the agency of the Department of Transport that regulates security. I should not say much more because I will get myself into a situation I will not be able to get myself out of." End of quote. Now, we will need to better understand what is being considered, what is being referred to here by the director of CSIS. Is some form of cross-the-border surveillance system to clock everyone's exits being contemplated? That seems to be hinted at within the statement, especially the sentence, "We do not even have a system to be aware when people are leaving." The suggestion is that such a system of awareness is some sort of a requirement, a sine qua non, for the protocols to be implemented to give effect to these new criminal code provisions. Of course, one way to be aware of someone exiting the country is to already have identified them as having the intention that this criminal provision talks about, and then to track them to the airport. But that kind of specificity may not be what Mr. Fadden actually is alluding to. Are we, to return to the question I've already asked once, are we looking at a more general surveillance system that CATSA, for example, would operate? We need clear answers on this in committee. Now, it might also be that a revision of the no-fly list is part of what is being contemplated as a general surveillance mechanism. At another point in his testimony before the Senate, Mr. Fadden discussed why no-fly lists do not currently provide the mechanism, A, for being aware of when someone is seeking to leave, and B, for preventing that person from boarding the aircraft. Here's his observation, and I quote, "The current structure of the no-fly list program is such that you have to be a threat to aviation. My understanding is that officials are preparing a series of proposals for ministers to try to make this list a little more subtle, but I do not know where they are on it." End of quotation. Now, is it possible that the government is considering a mechanism to put people on a no-fly list based on evidence, at whatever standard of proof, that the person intends to leave Canada in a way that would violate one of these new leaving the country provisions? If so, we need to know much more about how this would work in relation to enforcement of these new provisions in the code, and how people would be put on this list, and how they could get off. Will this be an alternative to arrest and possible prosecution under the criminal law provisions? If so, is this possibly preferable to direct intervention of the RCMP through arrest, followed by possible prosecution? I think in particular of how this would avoid criminalization of youth, who are the primary concern with respect to the kind of radicalization that leads them to want to leave Canada to get involved with terrorism. At the same time, however, what we know about how no-fly lists currently operate excuse me, Mr. Speaker, currently operate in a zone of non-accountability leaves me deeply doubtful that this approach would provide a preferable preventative mechanism. Just for example, the experience of Maher Arar and other Canadians like Mr. Almaty, and Mr. Nuruddin create real worries about what could happen to a Canadian who ends up on a no-fly list for reasons related to CSIS or RCMP speculation about intention to engage in terrorism. The Canadian government's purpose might be to stop the person from leaving Canada. Perhaps the purpose is to get youth to think twice before trying to leave Canada by another means. But foreign intelligence agencies that might get access to our no-fly lists might act very differently. On that very same information. If the person in question ever did leave Canada and then showed up on the radar screen of some country when seeking to use that country's airport. The reason this is of such concern is that the connection between a person and terrorism within this new leaving the country criminal law provision can be very attenuated. Intentionally attempting to leave becomes itself a terrorism offense, and the evidentiary basis for being put on a no-fly list, as opposed to being brought forward for prosecution, may be far below the standard of beyond a reasonable doubt within our criminal law system. And yet, on such a possible thin basis, someone's name could enter into the interconnected global system of surveillance that could lead to preventative arrests or worse in other countries on that basis alone. I emphasize that these are concerns prompted by an admittedly very brief reference from Mr. Fadden, but in the context, it is potentially a very telling reference. We must be aware how collaboration and information sharing works between intelligence agencies, between countries, something I've had the chance to study in some depth several years ago when preparing a report for the settlement process in Mr. Arar's lawsuit against Canada. Now, unless we have confidence in how people would get on this new, more subtle, to use Mr. Fadden's language, no-fly list, and confidence in whether and how and with whom the names on that list and the reasons for being on that list are shared, unless we have this kind of confidence, there is much to be worried about with respect to Mr. Fadden's revelation about a more subtle no-fly list. In any event, I think the point is clear that based on the testimony of the Director of CSIS before the Senate, this needs to have detailed testimony and scrutiny in committee after second reading in this House. Now let me now turn, Mr. Speaker, to a few comments, one in particular by Minister Nicholson when he was testifying before the Senate, by the Minister of Justice when he was testifying before the Senate. Thank you, Mr. Speaker. I remain a rookie at times. He talked about how investigative hearings could produce the evidence to discern the intent of a person to leave the country for purposes of terrorism. But we know that investigative hearing provisions that are being proposed to be restored in the Criminal Code by this bill state that testimony can't be used as evidence in court against the person giving that testimony. So this leaves us with one of two possibilities with respect to what the minister was referring to. The first is that he's actually thinking about using this mechanism as a mode of detention and arrest, but not necessarily going to prosecution. We return, therefore, to the problem of use of the criminal law system to allow for disruption with no real prospect for prosecution. More likely, however, the minister could not have meant that. He must have meant that investigative hearings will be used to question people about others' intentions and thereby use that as evidence for the attempt to leave provisions of the Criminal Code. But if so, this has profound implications for how often and with respect to what people these investigative hearings will be used as evidence-gathering tools, and we need to discuss this as well in committee, Mr. Speaker. Now, the minister also suggests evidence of intention to leave the country could come out of the hearings that deal with preventative recognizance, with conditions. And presumably, again, he means someone else is brought to such a hearing about some impending terrorist act, and information is then revealed about another person, and that evidence is then used to prove that person intends to leave the country for purposes of terrorism. We need to ask the minister and his officials what he meant by reference to these two sunsetted provisions, if they come back into law, as being mechanisms to gather evidence of intention to leave the country. And it does raise another question, Mr. Speaker, and here I think I'll be ending. Does the proposed new Section 83.3, resurrected from the 2001 Anti-Terrorism Act, allow for recognizance with conditions if someone can be shown to be on the point of leaving, because this is now a terrorist act? The intent to leave the country, when you attempt to leave, you are now engaging in a terrorist act according to the new provisions. And then they can be actually required to stay, their passport taken away, for up to 12 months. Is this scenario possible? Is this, in fact, a planned sequence? Does the government have this in mind? Keeping in mind how the United Kingdom actually uses control orders to prevent departures from the country, the question has to be asked whether or not this is something the government contemplates, a question to pursue, again, Mr. Speaker, in committee. With that, I conclude with the overall comment that there is much to look at in committee if we are to fully appreciate and make judgments about the utility of these new attempting to leave or leaving the country criminal code provisions. Thank you, Mr. Speaker.